reviewed the name of the king on the application of SO and Thanet District Council.
Yes.
I'm Mr. Baldwin. I appear for the appellant in this appeal/judicial review claim.
I think judicial review claim, as it now is.
I have Ms. Simac, who's assisting me as junior counsel, and representing representing Thanet District Council is Mr. Lane and his junior, Mr. Barber. We have a number of people in court today to observe. My lord, this is an issue. It's in respect of the legality of a direction notice that is at page 198 of the core bundle. And this is a notice that was served on the occupants of the land known as Ramsgate Marina, Marina Military Road, Ramsgate, Kent, CT11.
We don't need the postcode.
I'm obliged. The land that's identified, and there's an updated statement of Miss Turner, and that is in the supplementary bundle. It's a witness statement at page 161, and over the page is a colour photograph of the relevant land. And, my lord, you'll see that there's areas hatched, one area marked Area B and one area marked Area A.
But why do we need to know the details of the site? It may go to some point. I'm not quite sure what.
It's just for clarification that everyone is on Area B, and the Area B is land which is partly owned by the Crown Estate and partly owned by Thanet, but Thanet have a lease from the Crown Estate.
Yes, well, we've seen all that, and we have read the papers, so thank you, yeah.
And at present, the persons present on the land are not just the persons who were permitted to occupy, they are also the persons who were subject to the other directions notice. Those are identified as the unauthorised occupiers. There has been no enforcement proceedings against either group, and that
against either group? Sure. Not sure I understand what you mean. The quote's authorised. There have been enforcement proceedings. That's why we're here.
There are enforcement proceedings. What I meant was that there are enforcement proceedings, but those are adjourned, but they've not been taken forward in respect of the unauthorised occupiers. So both the unauthorised occupiers and the authorised occupiers still remain on the land.
Right.
So the list of issues in this case, the core issue here is in respect of whether any notice, precursor notice to the authorised occupiers of the site of withdrawal of their consent to occupy was required prior to service of the notice under section 77 of the Criminal Justice and Public Order Act.
Could we just get one thing clear?
Yeah.
You took us very appropriately straight away to the direction, which we have at 198.
Yeah.
It says it's under section 77. It doesn't say under what subsection or head of what subsection, but it describes it as unoccupied land. So it would appear that they thought they were issuing it under 77(1)(b).
But it must be issued under section 77(1)(c) because the Thanet District Council are the occupier of the land. and as occupiers, they permitted the group in which the claimant is part of occupy that land in caravans.
So what you say, in substance, although in form it appears to be a direction under 77(1)(b because of the language used,
Yes.
it is in substance a notice under 77(1)(c), is that right? A
That's
direction
my
under
submission.
77(1)(c).
That is my submission.
Right.
So the question that we have before the court relates to the two grounds of appeal. And the two grounds of appeal are in respect of the decision of Deputy High Court Judge Edis.
Well, but that's all by the by now, because this is a substantive judicial review, as my
Yeah.
lord has pointed out.
But the judicial review ground in my submission is in respect of ground one.
Yes, but I think that's phrased as a ground of appeal because that's what it was when you first drafted it. But because of the order of Lord Justice Bean, it's now a substantive ground for challenge
Yes.
in judicial review proceedings. So how would you formulate that?
The formulation would be that the District Council erred in law in terms of issuing serving the notice on the 1st of December 2021, and that was not lawful because there was no withdrawal of consent notified to those who occupy the land ahead of the service of that notice. So the argument is that in order to rely on that notice, because it is, in my submission, in substance served pursuant to section 77(1)(c), before the service of that notice, there must be notification to the occupiers of that land that consent has been withdrawn.
In your Stellish argument, you go rather further than that. You also challenge the absence of any evidence of a decision, notwithstanding the order of
Yes.
Mrs. Justice Lang. That formed part of your challenge as well.
At present, that is not part of the challenge. The reason why that is not the case is that the evidence provided by Thanet is that a decision was made, and that is in respect of a witness statement appended to the first witness statement of Catherine Turner of Thanet, the person who served the notice, whereby it says that a decision was made by someone superior.
Is that the one which refers to the senior management team?
Yes.
I mean, can we just look at what that evidence amounts to?
Yes.
Let's look first at Mrs. Justice Lang's order, which is in the supplementary bundle at 173. And it's order 1G, a witness statement which exhibits in support, addressing in detail I, the date upon which the temporary permission expired or was otherwise terminated, but I failed to mark up, but I understood that the evidence was also intended to cover the date of, to cover the making of the decision. Perhaps I've overstated that.
My lord, I think there is an overstatement. I just find that myself.
Well, G1 ends with the direction that evidence should be served dealing with the date upon which the temporary permission expired or was otherwise terminated.
And 6 focuses on what regard was had to the PSED prior to the issue of both notices, but we're concerned with the later of the two. So anyway, that's what we can see what the evidence was to cover.
Yes.
Then we've got Ms. Turner's witness statement, as you say, at 38 following. And she deals with the giving of the direction at paras 32 to 33, which doesn't really say how the decision was taken, simply refers to the notice and why they thought that the claimants didn't need to be there anymore. And then what your point is, your reference to an exhibit is to para 34, is it KT6? Is that right?
It's KT.
I'm afraid I hadn't followed this up, but I've seen the reference in the evidence. Do we?
It's KT7. It's page 73.
And where's the bit that comes closest to being an explanation of how the decision was taken?
If one turns over page 74, the paragraph starts, as I was walking back to the vehicle, Gypsy...
Yes, I see. Yes, thank you. There we are. Got it.
And
Senior
it's
management
the
team.
third sentence down, where there's reference to possibility of a judicial review. It was not my decision to serve. It says this would have been the senior management team, and I'm not the best person to speak to about it.
Yes, thank you.
So the indication from that evidence is that would be a decision by the senior management team. And just to identify who signed the notice of the 30th of...
It's signed by the lawyer.
Signed by Jennifer Phillips. And if one looks, there is the local authorities' policy in respect of these notices, which is at page 75 of the supplementary bundle.
No, this isn't surely their policy for dealing with these notices. This is their policy for dealing with unauthorised encampments.
But it does refer to, at page 81, my lord, choosing the most appropriate action.
for dealing with unauthorised encampments.
Yeah. And
Was this an unauthorised encampment?
No, it was authorised, but the argument is that by the withdrawal of consent it became unauthorised. That's the position of the local authority.
So where in this policy does it deal with how you convert an authorised encampment into an unauthorised one?
There isn't anything within this policy, neither is there anything within the policy guidance from central government either. But the decision about choosing the most appropriate action, if one looks at page 81, choosing the most appropriate action, it talks about the assessment. The most of the swiftest option will be taken by the Community Safety Unit in consultation with TDC Legal Service and Kent Police, and will be based on individual circumstances of the encampment on a case-by-case basis.
So what you're asking us to infer that the senior management team referred to in that witness statement from Ms. Turner, or Section 9 statement, is effectively the same as a community safety unit? Is
Well, I don't know. We've
Yes,
got a disclosure of that, but that is what the policy states as to who the decision makers would be in the choice of the form of action. But again, this refers to action in respect of an unauthorised encampment. There's nothing within this policy that talks about a situation where if you have an authorised encampment, even on a temporary basis, the approach to dealing with the use of enforcement action, including Section 77 notice.
Yeah, so as my lord has identified, the legal question is how an authorised encampment becomes unauthorised.
Yes, that initially was the ground of appeal that.
Well, now it's your substantive challenge. You say it was unlawful because consent was given and it wasn't withdrawn.
And it wasn't withdrawn, or if it was withdrawn, that withdrawal was not notified
Well,
to the occupant.
I think, but all right, I see the distinction you're making. It's not really the best way of making
No.
it, because withdrawal of consent must be a bilateral process.
Yeah. Well,
I don't see how you would withdraw it without communicating it.
Yes, I mean, I think to actually withdraw consent, it can be done, but then the second element of it is to communicate that
Yeah,
that was
all right.
happened.
Yes, but if you haven't decided to withdraw consent, you can't give notice
Yes.
that you have because you haven't done it.
No. And the notice itself, the statute expressly says, occupying the land without the consent of the occupier. The occupier is the local authority in this case. So the local authority may have made a decision within the senior management team that that was not communicated to anyone, including lawful occupiers, or
Well, yeah, but aren't you getting a bit ahead of yourself? Because, I mean, is not the next question to go to logically, what were the terms of the consent?
the terms of the consent, the best that we have in my submission is the arrangement in respect of the documents that are identified as the Code of Conduct documents.
Indeed.
Those are the only documents that refer to the conditions upon which occupation of the land.
Quite. Well, shall we look at those?
Those can be found again conveniently at exhibited to Ms Turner's statement denote 52 and 53, the two examples that are given. Now, these do predate the actual entry into the land.
They actually predate the identification of the land.
Yes,
don't they?
yes. But these are the documents that are relied on by the defendant as to the nature of the occupation.
Quite. And we see end date of negotiated stopping site, the use of the tolerated site and welfare to be reviewed every 3 weeks until further notice.
Yes,
So that looks like a rolling 3-weekly consent.
yes. And there is no precise mechanism specified as to what that form of notice is.
Well, no, but there is an undertaking, at least to give further notice
Yes.
if that period is being brought to an end.
Yes. So that is the best we have in terms of the agreements to occupy the land, and these are in respect of two named traveller families. So they're in respect of two traveller families. The second one at 53, that is the mother of the claimant. So that is what we have in terms of how occupation is permitted.
But I think also at the foot of the page, just above the signature, it says there'll be welfare visits, and this will give you a chance to tell us of any specific welfare factors you feel should be taken into account before a decision is made about the future of the stopping site,
Yes.
which would seem to suggest that there wasn't already a decision that would end at a particular point, but rather a decision was contemplated as being necessary in the future.
Yes.
Yeah.
And because the site is granted, and in my submission, this is somewhat of an unusual case in the sense of the use of these powers. The use of these powers are generally related to unauthorised encampments where people enter onto the land without consent, remain there. This is a situation where someone has consent to be on the land, but the issue is around where, when, and how that consent was withdrawn.
You say I've no idea whether it's like, it doesn't sound to me, possibly in the context of how you deal with travellers, I don't have enough experience to know whether it's a usual use of power, but it's quite a usual situation to give someone a licence terminable on a rolling 3-month notice period, or through a rolling period, however defined. That's nothing particularly legally unusual about that, is there?
No. But one should also look at the.
So can we just say, how do you actually say this, as you say, this is the nearest thing we have to any formal statement of the terms as regards duration and notice. What do you say this required the council to do?
I say that what the council should have done is that, given that you will have seen, my lords, from the evidence that the local authorities visited the site visits on a regular occasion to look at welfare needs, the state of the site, that in my submission what ought to have happened is that the local authority should visit the site, check on the welfare circumstances, offer general advice and assistance, and to give them a chance, tell specific welfare factors you feel.
Yeah, well, we can see what it says. What's that mean in practice?
Well,
does it mean that they should have said on one of their regular visits, we're thinking of terminating because we now think that your welfare factors which persuaded us to grants you this license in the first place no longer apply. What have you got to say about that?
Yes, my lord, that is what I was trying to get to. That,
Sorry, I got impatient.
The reason why the site had been granted was to deal with the issues around about the unwell child and the high risk pregnancy. And so the child, in respect to the high risk pregnancy, died unfortunately on the 25th of September. So, and the local authority then said, we will give you the appropriate period of time to grieve. In my submission, what should have happened is that there should have been a visit that occurred at a particular date prior to the 1st of December that looked at specific issues and then said, well, your need, effectively your welfare need to remain on this site has ended, and as a result we are considering ending.
Well, but as you've accepted, the decision-making process is not something that's before us.
No.
So the question then is, well, as you've accepted, there was a decision.
Yes.
And the question then is all about notice. And as I understand it, is this correct? That your case is that what they're obliged to do is they get to their 3-weekly review.
Yes.
And they must give notice and
They
say,
must give notice.
we now require you to vacate this site.
Yes. And that effectively that would...
How long notice?
Well, it's difficult to say, but in my respectful submissions, given that we're in a situation where the notice was served on the 1st of... The Section 77 notice was served on the 1st of December with the intention that notice be joined to enforcement proceedings that were to be heard on the 8th of December, so 7 days there. That in my submission that a minimal period would be 7 days prior to service of the Section 77 direction, if the local authority is still minded to use that as a mechanism.
I'm not sure I understand the logic of that. I'm sure it's my fault. You say that in fact it was served on the 1st.
Yes.
With a view to proceedings being brought in the magistrate's court, or a hearing in the magistrate's court on the 8th. But that's not any part of the part of the notice. That's just part of their thinking. Or do we even know that they were aware of the hearing 7 days thereafter?
Well, this particular group would not be, because they were not served with the summons in respect of that hearing. The summons in respect of that hearing was served on the unauthorised occupiers who were subject to the notice of the 13th of September. So they would formally not be served with those papers, but if one looks at what, to be fair to what Ms Turner says in her evidence at KT4, that she served the notice with a copy of that pack, so that they would not have been aware of the hearing prior to receipt of the pack with the notice, the Section 77 notice within it.
And forgive me, I haven't quite understood, I'm sure my lords have, what was the nature of the hearing of which you say they were served with notice?
The nature of the hearing is the hearing in respect of the magistrates' court proceedings.
Yes, but what were the nature of the magistrate court proceedings?
Those were proceedings under Section 78 of the Criminal Justice and Public Order Act. So those are proceedings.
Do we have the summons in the papers?
Yes, I think we do. The Magistrates Court proceedings start at page 179 in the supplementary fund box. And the complaint summons in respect of those proceedings can be found at page 192. And that is an identification where you are summoned to appear 1st of October at Margate Magistrates Court at 2 p.m. And that is dated 20th of September 2021.
And that's for the unauthorised group.
Yeah, because if one looks back.
Yes, but so in fact, you say Section 78 proceedings.
Yes.
These are actually. Yes, I see. Section 78 governs proceedings for an offence under Section 77(3). Is that right?
Well, if you fail to comply with the directions under Section 77, I think, my Lord, it may be useful just to look at Section 78, which is in the authority.
Yes, I was just looking at it myself. So I'd rather focus on Section 77, but.
So the offence is under 77 subsection 3, isn't it?
Yes.
Yes, so Section 78 is different. Section 78, as you say, is a complaint which will lead to an order which effectively allows the local authority to use force to clear the land.
Yes, my Lord, but it is linked to Section 77. If one looks at Section 78 on page 5 of the authorities bundle, under 78 subsection 1, it says, and this is orders for removal of persons' vehicles, it says a magistrate's court may, on complaint made by the local authority, if satisfied that persons and vehicles in which they are residing are present on the land,
Yes.
within local authority,
Yes.
they're in contravention.
So if you get a Section 77(1) situation, there's two chains of consequences.
Yes.
Consequence 1 is if you don't leave, you may be committing a criminal offence under
Yes.
77(3), for which proceedings can be brought against
Yes.
you, and summary proceedings, and no such proceedings have been started.
No.
The alternative, the second, is that it is a 77(1) situation.
Yes.
Or to be accurate, I think, yes, a 771 situation is a prerequisite for an enforcement order, which will allow the.
Yes.
Yeah. Sorry, that's all pretty obvious, but I hadn't just spelled it out to myself.
But that is the situation there.
So am I right in understanding that the document to which you took us at page 192 is doing two things? First of all, it's initiating criminal proceedings for the offence under Section 77(3). Secondly, it's seeking a removal order under Section 78(1). Have I got that right?
As I have understood the case as it's presented, that the summons at 192 is limited, in my understanding of it, in respect of the removal of persons from their vehicles.
Yes.
It's not in respect of the criminal offence at 77(3).
Well, that's how I'd read it, but it is a bit ambiguous because it's described as a complaint and summons.
Yes.
Is summons the correct terminology when no criminal offence is being alleged or prosecuted? Maybe it is.
Well, this is a mechanism whereby...
Perhaps it is. You're summoned to appear to answer the complaint.
Yes. So the complaint is laid before the magistrate's court, and the magistrates then issue a summons.
Yes, I see. So, in answer to my Lord's question, you say no. There's no element of a prosecution here. This is simply a complaint applying for an enforcement order.
Yeah, Mr. Lane.
I'm sorry to interrupt, my lord. I just thought it may be helpful to have a look at page 182, which is the case summary presented. And the opening paragraph of the introduction makes it clear that it's a removal order under section 78, not a section 77(3) complaint.
Well, you're told in a document that refers twice to 77.3 and not at all to 78.1. But there we go.
Well, yes. I mean,
How the lay reader of the document is supposed to know that is a mystery to me.
well, certainly what is, I accept that point, my lord, but certainly what is being said, of course, is that you need to leave the land. And obviously, in a legal sense, that's by reason of section 78. But I appreciate.
Who drafts these? Presumably Ms. Phillips or someone in her team.
I can turn my back and check, actually. Apparently, they're precedent documents that the local authority have and use. I don't think it was Miss Phillips who sat down and
Drafted them.
drafted it, but they were made available to her from previous precedents.
Yes, I'm just checking.
But in answer to my lord's question, of course, he's absolutely right to say no reference to section 78, although, of course, there's a reference to a removal order. And, of course, that postdates the actual removal order.
Yeah, perhaps the reference to 77.3 isn't wholly inapt, because 78.1 refers to the fact that a direction has been given, which is 77.1, but it also refers to a contravention of the direction given.
You can't get a removal order unless you can prove the offence.
It's effectively,
Yes.
it is effectively
Yes.
77.3, yes.
Because, of course, you can stay on the land for as long as practical. You
Yeah.
need to leave, for example. Which is one of the defences. So it's absolutely right, my lord.
Yeah. Okay, well that's been helpful in just seeing how it all fits together. I'm sorry, yes, Mr. Baldwin, we taking you away from your thread.
My lord was asking basically what would be, as I recollect, the notice period in respect of the termination of
Yes.
before you then seek to start proceedings
Yeah.
in respect.
And you suggested 7 days, but your reasoning appeared to be that in this particular case it happened to be, which is just a happenstance, 7 days to the hearing, of which they were not parties in any event.
Well,
So I'm not sure that's quite...
Well, my lord, in terms of whether or not they were a party, if one looks at what Ms. Turner actually said in her statement.
I'm sorry, that was an unnecessary refinement on my part. It is nevertheless a happenstance that on the
Yeah.
facts of this particular case, there was a hearing in 7 days' time.
Yes. But what they were served with these papers, the authorised occupiers, I'm going to call them that, were served with these papers and identified, and Ms. Turner identified to them that.
Well, I guess my lord suggests that's a bit of a distraction, isn't it? I mean, as I understand it, your case is that there must be reasonable notice,
Yeah.
and your submission is reasonable notice must be not less than 7 days. Is
Yeah.
that correct?
Yeah.
And what is that based on?
Well, I think it's based on an idea that the difficulty is that to come up with a notion of a reasonable notice in terms of the persons on this land who were let on the land, that you do see a range of families, you see people with many children, and that the week, what you might call the weekly notice, the notice period within the agreement was 3 weeks.
Well, it's not quite that, is it? And that's what I was thinking. It says we will review the position every 3 weeks. That doesn't mean that you should be looking at your calendar and every 3 weeks from day one, you may be told to go at once.
Yes, I mean, the difficulty is that we're in a situation where we have the best evidence as to the terms of the occupation are these code of conduct agreements. Now, the difficulty in terms of identifying what is reasonable notice, in my submission, may depend upon the individual circumstances of the individual occupiers. And that...
Yeah, well, that's fine. I mean, it would be a perfectly respectable answer, Mr. Baldwin, to say that there is no... that to terminate consent, you must give reasonable notice,
Yes.
and what is reasonable may be different for perhaps in the case of a single traveller who can simply start the engine and leave, and what may be different with a complicated family with health issues and so on. That's fine.
Yes.
But I wanted just to pin down what your case was, and 7 days might happen to be reasonable in a particular case. You might say some days not even that would be enough.
Yes. Yes, my lord.
You might say you might pick up on the 3 weeks, although the 3 weeks are not said to be a notice period.
No.
You might say that in practice the thinking behind that is that every 3 weeks you would know whether you would have another 3 weeks.
My lord has picked on the difficulty I have in formulating a precise answer, and that is that the reality is that reasonable notice will depend primarily on the individual circumstances of the individual occupier.
Well, that's fine. I just wanted to know, because of course one answer to your case, we haven't come to the main answer to your case yet, but one answer to your case might be that it's, if you have to give prior notice, couldn't they just have given it to you a minute before or an hour before? One's got actually to work out what principles are working here. It's not just the fact of prior notice for some technical reason.
In my submission, it would be reasonable notice based on the individual circumstances.
Well,
what you have also within that context is a certain level of infrastructure and assistance that's been given. So that would also have to be part of the considerations within the reasonable notice.
Okay. Well, this isn't a case where some notice was given and the argument is whether it was reasonable.
Yes.
So we don't need to go into that. I just need to know in principle what your answer was.
Yes.
Okay.
Because in the case of, in other areas, not Section 77, but where you're terminating someone's right to live on it, or the fact they have been living on a particular site, so in the planning injunction category in the South Bucks case, you have to do quite a lot as a local authority in terms of making those decisions.
Yes.
You have to consider the public sector equality duty, you have to consider the impact of such a decision on the people who are living on the site, you have to think about their state of health, their educational needs of the children, all these sort of things, and there's a lot of authority about what's required when you're bringing to an end occupation of that sort. What do you say is required in this context?
I think, my lord, possibly the best analogy to this context is accommodation, that's temporary accommodation provided under, say, Section 188 of the Homelessness Act, where to terminate that type of accommodation, you do need...
Sorry, Section what? Section
1881 of the Housing Act 1996, where there's virtually no security of tenure. There is a license agreement, and that what is required there in terminating that is reasonable notice. But again, it depends on the individual circumstances of the occupiers. Say a single person, in those circumstances, reasonable notice might be 24 hours, that they have no dependents, no health issues. But if they have many children, health issues, so on and so forth, in order for them to find other accommodation, they may need a longer period.
Is there authority about termination and occupation under Section 188?
There is. I don't have it to hand.
Well, what does it say in broad terms? Does it just say reasonable notice?
Yeah.
Yes, I said, which will depend on the circumstances.
Yeah. And Mr. Lane can address you on that.
So to act lawfully, a local authority would have to address its mind to the question of what in the particular circumstances was reasonable notice.
Yes. because as
I should just say, my lord, that the case my learned friend was referring to was a case of CN and Lewisham, London Borough Council, which is a 2014 case in the Supreme Court, UKSC 62. And the appeal case is at 1259. Not in the authorities one.
No, I was just checking. I didn't think I'd seen it.
Sorry,
And that was a case as to whether, in fact, for example, a notice to quit was required, or whether they could simply change the locks but give notice before doing so.
That seems quite a close analogy to the present case. It wouldn't not occurred to either party to draw it to our attention.
Well, I've got it in my speaking note purely because it came up while I was thinking through.
Yes, I see. You know, I'm very impressed.
But I'll deal with that obviously in my response.
Yes, thank you. Yes.
So I think that is the best that we can.
Yes. No, I see. Well, may I then just put to you what I think? We'll find out what Mr. Lane's point is, but this is certainly one way it seemed to me. Couldn't it be said, yes, you do have to have notice, of course, because you've got to have a reasonable time to leave. But why should the Section 77 direction not itself be the notice that your right to terminate, the consent to your occupation is terminated? It doesn't immediately make you mean that you are committing any criminal offence. You will only be committing a criminal offence if you don't then leave within a reasonable time. So why shouldn't the direction be the notice of withdrawal? Why does it have to be a separate and earlier document?
Well, my submission is this, that the notice is predicated on the concept that consent has been withdrawn. Now, the notice itself says the person occupied land and you together with any other persons are directed.
Well, I mean, our problem, of course, is we don't know what it would look like if it was a notice under 77(1)(c).
Yes.
Probably it would look very like this.
Yes.
But there might, for example, be a recital saying consent having been withdrawn.
Yes.
Or it might say consent being hereby withdrawn.
Yes.
We just don't know because we haven't got one.
But this is the problem with this notice. This is a pro forma notice.
Well, your point is the wrong pro forma notice.
Yes.
It's always need to be a pro forma notice.
Yeah. So the problem is that this notice itself does not refer to consent being withdrawn. What is provided for within section 77(3), and that is if a person knowing that a direction has been given to him which applies to him, so that is applicable to him, he fails as soon as reasonably practicable to leave the land or remove from the land any vehicle or other property which is subject to the direction, or having removed any such vehicle or property again enters the land.
Yeah, well, we can see what it says. So what's your point?
The point is here is that you're given a notice that the direction is to leave the land forthwith, but the compliance with the notice is to leave the land as soon as reasonably practicable, in the sense of if you fail to do so, then you are subject to...
Are you making a distinction between forthwith and as soon as reasonably practicable?
Yes, because it cannot be that forthwith of itself is reasonable notice. And it cannot be, in my submission, that even if there's a saving part of it in respect of committing the offence or being subject to the removal direction, that is then subject to leaving a land as soon as reasonably practicable.
By the way, the language is practicable, not reasonably practicable. Yeah. Yes, I see.
So you've got to get off as soon as you can.
Yeah.
How's that different from forthwith?
Well, you get off the land as soon as you can, but it's dependent on again what is reasonable for you. But that is something that should be, in my submission, in the body of the notice, given that we're in an unusual circumstance where you were given consent to remain on the land. It's a very different circumstance to if you had no consent.
Forthwith normally means immediately.
Yes.
Yes, but my lord, the Chancellor will probably have more experience of this. I think there is case law that says forthwith certainly requires a degree of urgency, but it's not immediately. And you do see cases which says it means something like as soon as you can.
Yes.
I think, but I suspect if you look deep into the case law, it'll say, as case law tends to say, the exact weight to be given to forthwith depends on the circumstances.
It's context dependent.
Yes.
So we again come back to the context and also the consequence for non-compliance. The consequence for non-compliance is, in these circumstances, enforced removal.
And criminal conviction.
Yes.
Offence being committed as soon as whatever the moment is when it becomes practicable to leave, as soon as that moment arrives, you're guilty if you haven't left.
Therefore, that means that, if I understood you correctly, that if that is the effect of giving the direction in a case where you have previously had consent, you would expect the draftsman to be intending that the consent will have been terminated previously by the giving of reasonable notice.
Yes.
Yes, I see.
So it's the presumption against doubtful penalisation.
Yes.
That's the canon of statutory construction.
Right. Well, partly by a dialectical process, we've really got most of your submissions on ground one out of you, haven't we? You do say if we haven't, because you've mostly been answering our questions, which has been helpful.
Well, Lord, I think you have. I'm looking at my note, and in respect of ground one, and my note, there's nothing more that I think I could usefully add in respect of the ground.
And does ground two really add anything?
Not really, my lord. If your lordships are against me on ground one, it doesn't add anything, and if you're with me on ground one, it doesn't really add anything.
No, and actually it's all about the weight that the judge gave to a piece of evidence.
Yes.
Well, we're not interested in that
No.
because we're doing this from the
Yes.
start.
Yes. My lords, unless there's any other questions, I mean, they've been very useful questions.
No, thank you very much, Mr. Baldwin. That's been helpful. Unless my lords have any questions. Yes, Mr. Lane.
Thank you very much, my lord, and grateful to my learned friend. And of course, we now see the case much more clearly, in a sense, and certainly cases that was presented in the court below, but certainly also in how it's been presented here today. Certainly, there's no question being raised as to the lack of decision. Certainly, there's no question being raised by my learned friend as
It's a bit surprising that we know so little about the decision.
It is, but it is. I'm afraid we are limited to what you've seen in Miss Turner's statement and the references that my learned friend has taken you to.
Wouldn't one would expect, with a decision of this kind being taken, to see some sort of minuted formal decision within the council by a decision maker.
My lord, one of the difficulties of dealing with this on this ground alone, because obviously I won't make any submissions on ground 2, given my no defence understandable position on that now, it is that of course it ignores what has already been accepted by the court below. And as you well know, my lord, what was before Mr Justice Ellery, KC, and was actually challenged there, but is not pursued here, was with regard to questions such as welfare inquiries. And of course the fact that it was said that they weren't sufficient, those are my words, not the actual grounds themselves, but it was said that they weren't sufficient. But of course they were an integral part of this whole process, because of course the only reason why this particular cohort, and I don't mean any disrespect by that, but this particular cohort were on this site was because of particular welfare inquiries.
Well, indeed, and the evidence includes the equality impact assessment, which was quite properly produced. Just a bit odd that what one might have thought was the accompanying document saying, on the basis of this EIA we now decide,
Yes.
is missing.
Well, I accept that, my lord, and I can't do any more than say it is what it is, and it is before you.
Yeah.
What we do know, of course, is that, and we see this in particular, of course, from the statement of Miss Turner, and if I may refer you to that so that we don't go backwards and forwards to that statement, I'll just wish to address you on that statement now. And that's a statement that starts on page 38 of the supplementary budget.
Sorry, looking at the wrong bundle. Just a moment. Yep.
And my lord, you'll see, for example, at paragraph 6 on page 40, a potted history of the local authority's understanding of this particular family, and that would include right back to 2019, as you see at subparagraph 1, and the reference to welfare forms even at that early stage being prepared. And that's a theme that you'll see throughout many of these references as the time moves on. And you'll see at 5 there is reference to an unauthorised encampment at the water treatment plant in Princess Walk. It included this family, and it talked about a high-risk pregnancy going over onto page 41. And then there's reference to the court matter, which is also dealt with on page 42, but there's reference to the court matter to remove those occupying that particular site.
Yeah, we are aware of all this history. What's the point you're making?
The point I'm making is that one of the issues raised was the use of welfare visits to advise, and the point I'm making is that firstly, there's no challenge to the fact that the local authority made legitimate and proper welfare inquiries of the family, and also the only reason why this group of travellers was on the site was because of particular welfare concerns which had been raised at the Magistrates' Court in May 2021.
To be sure, the point is well made by you that welfare considerations were thoroughly investigated and fully taken into account, and moreover, it's not before this court anyway. That's all understood. But for our purposes, surely what's more relevant about this paragraph is the distinction that's drawn, because in subparagraphs 2, 3, 4 and 5, we have repeated references to unauthorised encampments, whereas when we get to 7, which is the material one, it's a temporary stopping site. So it's not an unauthorised encampment.
No, and as you'll have seen from my skeleton argument, and indeed, I don't think it's disputed, and indeed the ground is laid out in such a way so as not to dispute it. There's nothing to stop a local authority temporarily allowing a group of travellers or even just one caravan of travellers staying on a piece of land, and as we say, as you know, making it very clear this is a temporary arrangement because of welfare concerns about those families, but still using section 77.
Well, that's fine as far as it goes, but if it is not an unauthorised encampment, but somewhere where they have been allowed to stay, however temporarily, however much for particular reasons, the legal situation is completely different, isn't it?
Well,
Because you have granted consent,
well,
and you've got to terminate the consent.
well, we say not. We say of course there has to be a lack of consent in order for Section 77 to be operable. Because of course this is dealing with unauthorised encampments, whichever provision one is dealing with. But what we say is twofold in a sense, my lord. One of which you indicated we might say, which is that the notice itself, that's the direction notice itself, that was served on the 1st of December of 2021, is sufficient for these purposes, and I'll come back to that. And the second is that formal consent, i.e. written consent, whatever period of days is required, etc., it is not required.
Formal consent or formal termination of consent?
Sorry, formal termination of consent. Sorry, my mistake, I apologise. Formal termination of consent is not required because the families were aware throughout of the temporary nature.
Well, that won't do. That won't do, will
Well,
it? I don't know what you mean by formal. I dare say that it wouldn't be a very good practice that just coming and telling them without a piece of paper might well, in principle, do. But the real point is that they have got to be told effectively that their presence on the site is no longer authorised.
yes,
Now, you've got your separate argument, well, that's what the direction notice does.
yes.
But subject to that point, that never happened, did it? Formal or informal?
There was no formal consent, otherwise, of course, you...
No, you mean no formal termination of consent?
No formal termination, sorry. Yes,
Well, there's no informal termination of consent either, was there?
Well, save that, of course, what the families knew was that they were there because of the welfare concerns which were dealt with and overcome. And you'll have seen that from Miss Turner's statement.
Well, all right. Can we just analyse that?
Yes.
You let us suppose that the notice said, or the original consent said, we are giving you this right because of the welfare concerns. The welfare concerns are our worry about the pregnancy, but it will terminate 14 days after you've had the baby, say, and or in the case of the other child after it's been discharged from hospital, say. Then I can understand an argument that the consent would automatically terminate because there's an objective test by which they know that the consent ends at that point. But it was never as precise as that, was it?
No.
It was simply in terms of our welfare concerns.
Yes.
And obviously they knew roughly what the welfare concerns were. But unless it's as precise as I've suggested, surely you would have to say, right, we have now taken the view that the welfare concerns that justified us granting our consent have come to an end, and you must therefore leave within X days.
I would accept that the termination of consent conditions, as it were not clear, certainly from the Code of Conduct.
Well, okay, can I ask a couple of questions before we just get on to the details of the Code of Conduct?
Yes.
Question one, suppose a hypothetical in which the council had granted a fixed 6 month period. So they said you can stop here temporarily, 6 months, that's it. After 3 months, they serve a Section 77 direction. Is that lawful?
Well, if one is granted a fixed 6 months, whether or not one calls that a tenancy or whether one calls that a licence.
It's a licence. Call it a licence.
Then, of course, one can only end it on the terms of that licence.
Quite. So you are therefore accepting that a Section 77 direction cannot override what has been agreed between the parties.
Well, it depends what's been agreed between the parties, my lord. Because if what has been agreed between the parties is not a fixed term, for example, as is not the case here, of course. Sorry, as is the case here, there's clearly no agreement to a fixed term. And if it's on all fours with the fact that this was a temporary arrangement of unknown period because of the fact that it was related to welfare inquiries, I appreciate that the equality impact analysis talked about 5 months, and I appreciate that the Code of Conduct at the time, of course, before the site was actually identified, was talking about a more generalised kind of question. But there was certainly no fixed term provision there, and there's certainly nothing, and I'm going on to the argument, I suppose, as to
you're of course absolutely right. So my example was deliberately hypothetical, but that then takes us to the terms of this consent.
Yes.
And do you dispute that the best evidence we have is the 2 Code of Conduct documents?
I say that is part of, I think it's certainly important evidence, and I say it's part of the overall picture. But, my lord, I do urge the court to consider it in the context of the dealings that the council were having with the family, both in terms of the May 2021 Magistrates Court hearing and the concerns of the court at that particular time, hence the move to this site. And the evidence of Miss Turner in her statement. And this is part of that, because, as I say, this wasn't actually at this time referring to a particular site.
Can you enlighten me? How do the 2 affected families know when they are supposed to leave this site, if not from the terms of this document?
Well, they know because the council will inform them.
That seems to be an acceptance that they're required to give, the council is required to give notice.
No,
but your argument is to the contrary.
No, because it's an acceptance that either, and I appreciate this is the second argument, either the Section 77 direction notice is sufficient to inform them, or the mere fact of the reasons why they were on the land in the first place with consent was no longer operable because of the welfare concerns which were known to them, which were known to the council, had been addressed. And that's Miss Turner's statement. That's the evidence that she gives in her statement, that the welfare concerns were being addressed, were being monitored, and had been overcome as far as these particular families were concerned.
Well, that is apparently the council's view, and that is her evidence, which we can't go behind, and I see why they reached that view. But how would the families know that the council had reached that view?
Well, the families would have known that the welfare concerns had been overcome, because of course they were the ones experiencing those concerns.
Well, but that really comes back to the question I put to you a few minutes ago. If the conditions had been expressed in precise terms, the welfare concerns had, as it were, been formulated and said, this is what we're looking for, discharge from hospital, birth of the baby, whatever, then you're right. The families would know just as well or better than the council that was the case. But as soon as you accept, as I took you to accept, that the welfare concerns were not formulated in those precise terms, it becomes a matter of judgment, doesn't it, when they have been overcome?
Certainly in terms of timing, I would have to accept.
Well, timing is what we're talking about.
Yes, of course, but I would accept that there must be an element of timing in that, because these are not perhaps binary questions sometimes.
Well, take the question of a grieving period.
Well, that's one of the examples.
How long? How do they are supposed to know when the council thinks that they've had sufficient time to grieve? And what if there's a difference of view on that?
Yeah. And it's more complicated still, isn't it? Just because, in fact, as it turns out, very sadly, the baby died. But all that was known at the time the tenancy was granted was that it was a very high-risk pregnancy. But things that happened differently, we might not be talking about a grieving period at all. But that just shows we're looking into something that at the time the conditions were formulated was a bit of an unknown.
Yes, I have to accept that, my lord. I mean, it clearly was unclear, which is why, of course, you don't have an actual end date
Right.
the fixed term that my lord was talking about.
So what's your answer to the proposition that on the face of the document, it's a rolling 3-week consent?
Well, I think our position is that clearly it's under regular review by the local authority, and that it was, as confirmed in the court below. And the notice given, as it were, was not referenceable to a separate notice, but was a mere fact that the prior consent would not be continued once the council was of the view that it was no longer required. Because, my lords, one has to look at the section 77 and 78 process, and I know we have looked at the particular provisions already, but to see exactly what those do, both in terms of the second argument as to whether the notice is the answer to the question, or indeed whether our first proposition that you've seen from our skeleton argument is sufficient. In other words, that they knew it's a temporary stopping site and that therefore it was the council that had to be satisfied, and it's the council that could simply withdraw its consent and no formal notice was required. Because the section 77 notice, it's not a particularly good analogy in some ways, but it is almost like the distinction between a notice to quit and a notice seeking possession, in the sense that a notice to quit does something, i.e. it brings the tenancy to an end, whereas a notice seeking possession clearly is just a warning. You know, the landlord in that example may or may not do something because of the alleged breach of tenancy. And here, of course, with a section 77 direction notice, there's no requirement or no certainly obligation of a local authority to actually do anything once it's served. It obviously can do something. There's no obligation for it to do anything once it's served. It is effectively and clearly telling anyone in receipt of that notice, you're no longer entitled to be here. And I suggest, my lord, whether one sees it as no longer or never have been, makes little difference. It's clearly the local authority saying you're not entitled to be here.
So we're now slipping perfectly reasonably, but we're slipping onto your first point, that
Yes.
the direction notice is the withdrawal of consent,
Yes.
or the communication to withdrawal
Yes.
of consent.
Because if one says, well, that's very unfair, isn't it, for a family who, that's the first notice they get, that they can't any longer stay on the property, on the land, and that's the withdrawal of consent. But of course, it's not an absolute.
I'm sorry to
Sorry.
interrupt you, but can I be clear?
Of course.
When we read in date of negotiating stoppage site, and we read the use of the tolerated site and welfare is to be reviewed every 3 weeks until further notice. On your submission, as I understand it, you can have a 3-weekly review, and the very next day, in which nothing is said about bringing the use of the site to an end, and yet the very next day, the council can serve a section 77 direction,
Yes.
and it has immediate effect.
Yes, subject to what I'm going to say about the actual operation of section 77, but yes, my lord.
How can you square that with the wording of the document?
Because one has to appreciate what section 77 actually does and the restrictions it actually imposes on a local authority such as Thanet in this case, and under these circumstances. Because although obviously in principle, nothing to stop a local authority both issuing a notice and issuing a complaint in the magistrates' courts under 77.3 or seeking a removal under section 78. But of course there are certain protections for occupants of the land against such an arbitrary use of that procedure.
Namely?
And what you've got, of course, is that, although this isn't relevant here because as you've seen, and as I've taken you to, it's not part of the actual magistrates' court proceedings, but we've had the fact that the removal of oneself from the site is only as soon as practicable. So But whatever the notice says, whether the notice says forthwith, whether the notice says 2 days, whether the notice says 4 days, it's as soon as practicable. No offence is committed as long as the period wanted or required by the people on the site is as soon as practicable. That is clearly a matter for the court, of course, as to determine that matter, but that is one protection for them.
But would you accept that what is practicable may depend on the extent of prior notice that's been given? If you're told 3 weeks ahead, let us say, you've got to vacate a site on a particular date, then you can make preparations and plans.
Of course.
If you're not given that notice, then what is practicable may be rather different.
Absolutely, and of course I accept that, my lord. Absolutely. But that doesn't mean that the notice doesn't have the effect I say for it. It just means that its operation and how it can be used by the local authority is informed by that process. And certainly if in this instance, for example, the local authority had given notice, let's say the 3 weeks that you talk about, then of course the operation of section 77.3 and the interpretation would be very different as to how long they should be given, assuming there's no other defences to the claim. But equally, of course, even if they decided that, well, actually, we don't agree with your welfare assessments, even if we feel that, you know, you've been a bit slapdash with that, and I say that's not a ground here, dealt with below, but you have subparagraph 5, of course. It allows a defence to show that the failure to leave or to remove the vehicle or other property as soon as practicable, or as re-entry of the vehicle was due to illness, mechanical breakdown, or other immediate emergency. So those are matters, of course, for the court. And in a case where, such as this, where there hadn't been the prior notice that my lord referred to in any clear sense, then of course, and this is the only document that I can point to that shows you that in fact the local authority were no longer willing to continue the consent, because clearly the implication of the section 77 and we want you to get off the land forthwith is clearly a removal of consent. There is that protection to them. In other words, how quickly they move off is as soon as practicable, and if there are other welfare issues, they're entitled to raise those and defeat any claim under section 70. Any complaint under section 77.3 in the magistrate's court in the usual way. In terms of the order for the removal.
Well, hang on. Can I just be clear about that? Suppose they were to say, effectively, this was unreasonably soon, but they don't take a point about prior notice. They say, well, they say we have had no prior notice, therefore we need much longer, and there are these welfare concerns, and so we need at least a month, say. That would be a defence to criminal proceedings if the magistrates accepted that, but you wouldn't know whether they would or not, because it would be a matter of judgment. It would also be a defence to a section 78, or reason for granting a section 78, or because you'd rather show contravention. But is reasonable practicability the only tool, or would you be able to, well, you would presumably be able to deploy Article 8 considerations, so they would effectively raise the same sorts of points as the concept of reasonableness, or would they? Concept of practicability, or would they?
Those tend to be matters for the administrative court rather than the defence in the magistrate's court. But they certainly can be raised in one form or another. And of course, as you'll know, my lord, in this case, there were references effectively to the public sector equality duty in terms of the local authority's operation.
Well, that is a different matter. I mean, because you are insistent, and Mr. Baldwin doesn't appear to see it differently, that the lawfulness of the prior decision is not being challenged. I'm just interested in what the position would be without bringing judicial review proceedings against the prior decision, whether on Article 8 grounds or PSED grounds or anything else. But actually what you could raise in the magistrate's court. And you could certainly, because the statute says so, say the period in question is not a practicable period. In principle, surely you could raise Article 8, couldn't you?
In principle, I mean, there is an authority in the bundle at page 233, which is the Crown and Wolverhampton Metropolitan Borough Council. It's hardly done and rapid.
Yeah.
And you'll see that on page 234 in the facts of the matter, direction was served on the applicants in the second paragraph down, requiring them to leave the land. Two of the children were discovered at that time as being registered blind. The authority laid a complaint 4 days later before the magistrate's courts under section 78, similar to this case in some instances. The hearing of the complaint was adjourned on a number of occasions to allow the authority to undertake inquiries into the applicant's welfare, housing, educational and health requirements. And on March 1996, some 6 months later, the stipendiary magistrate upheld the complaint and made an order authorising the authority to enter the land, etc. And that was challenged, the applicants were successful in their application, and you can see why. It talks, for example, about the Criminal Justice Public Order Act, Section 77 and 78, are intended to provide a swift means of evicting travellers from land. Careful consideration is required before using it. Once the decision is taken to use the procedure, there should be no more delay between the giving and enforcing of the direction than is reasonably.
So where are you reading from?
I'm reading from 234 and what the court held about halfway down, paragraph 1 of the held section.
Yes, I see.
234.
Well, we can read all this. The bottom line,
But
as I understand it, is that they said the right target should be the local authority's decision rather than the magistrate's order.
Yes.
So that suggests that when you say there are adequate safeguards at the magistrate, adequate safeguards is understood you to be saying because the magistrate may acquit if it's a prosecution under 77.3, or may refuse to make an order under 78 if it wasn't practicable. But that is it. The only tool is that you couldn't, in effect, invoke any other public law consideration.
It certainly that seems to be that's the ratio of that authority that says.
Yes, that's of course it is a pre-98 Act authority.
Yes.
Because the Magistrates' Court under the Human Rights Act would have obligations in relation to Article 8 rights.
Well, absolutely. But my Lord, and I appreciate your Lordship's points about my references to Section 77, but they were deliberately focused on the Section 77 restrictions, as it were, which magistrates' courts would be able to look at, because, of course, they would have to be satisfied before making any order.
Yes, but I just really wanted to understand this all ultimately fits into your argument, saying it's not unfair to treat the direction notice as itself the withdrawal of consent. And one of the reasons why you said that was that it's not the end of the road. It only requires you to leave or makes you commit an offence if you don't leave as soon as practicable, and that effectively gives you an extra safety net. And I was just seeing what the safety net consisted of.
And I accept, and of course, as you say, it's an old authority, and it may be, one may argue differently, but I don't think it's been overturned, or I don't think it's been dealt with in any subsequent authority in any negative sense. And it may be that if one wished to argue a much wider set of defence, one would have to go for judicial review of the decision. Of course, in this case, it's specifically not a challenge to a decision. I mean, that's the actual application form made it very clear it wasn't a challenge to the decision. It was to the enforcement that was actually being challenged, and not the decision itself. But I take your lordship's point in terms of what one would normally see in such matters. But yes, so we say that there is that clear protection that is available, and so what one knows from that, if one stands back, is that let's say I am SO. I know from that I've been allowed onto the site as a temporary measure. This is what I say the evidence shows. I know that that's because of welfare concerns, because in respect of my family. I know that that I should expect reviews of those welfare concerns, and indeed the evidence is that they're carried out, and that was accepted by the court below and isn't challenged in this judicial review. And I know that the local authority no longer wish me to be on this land because I have got a Section 77 notice.
But you don't know prior to that?
I don't know prior to that specifically, I accept that. But I do know now. And I know that the matter is a matter for the court. Now, whether that's...
What do you say about the fact that, on its face, the Section 77 direction appears to be inapposite, in that it refers to unoccupied land, whereas what we're dealing with here is occupied land? Would you say that's simply irrelevant?
I don't think it makes any difference to what is being requested by the local authority, which is simply that, and it certainly isn't misleading to the...
Well, but is that right? Because it's treating the case as if it's an unauthorised encampment, whereas that's wrong. This was specifically consented to. Stop it.
Well, my lord, I don't accept that analysis, because I say that the fact that it was at one stage accepted, and of course the majority of them, that's not the case. The fact that it was at one stage accepted doesn't make any difference to the ultimate fact is that it's no longer accepted, and that certainly there are people on this land who the local authority wish to leave, and of course they can't.
Well, but it leads back into the local authorities' thinking. Because they thought it was a 77(1)(b) case, they didn't have to think about consent at all.
Well, I can't, in a sense, make any submissions on what they were thinking, whether that was uppermost in their mind or whether that affected.
Now, I suppose you would say, well, it might be relevant if there was a challenge to the decision, because one could say the decision was taken on false basis.
And it may be something that certainly the magistrates court could look at if they took the view that the Section 77 direction was invalid for that reason. Then, of course, they could look at that, because, of course, they clearly have authority over Section 77 itself and the statutory references. But obviously, that's not a matter challenged here. But in terms of whether one can go further,
there's nothing that tells us why. I mean, why this form of notice was used.
Well, there's certainly nothing that would suggest, my lord, that this was produced in such a way as to almost mislead the local authority itself into thinking they didn't need to give prior consent.
Well, I think there is. I mean, your better line is to say this might be a basis for challenging the prior decision, that they approached it on the wrong basis. But it's pretty. There must presumably be a occupied land form and an unoccupied land form, and whoever in Miss Phillips's office had to choose which one to use, and they obviously choose the wrong one, because this was occupied land within the definition of it was a slightly odd definition in the Act, but it's clear it is occupied land. And therefore, if they had been thinking about it, if they had chosen the occupied land form, which we don't know what it looks like, but would presumably refer to consent. Well, certainly anyone looking at it would say, this is 77(1)(c), and therefore we have to address the question of consent.
Save, of course, that the evidence you do have from Miss Turner is very much in relation to not only how they came onto the land, but the fact that that was no longer operable and there was no longer consent. So,
yeah, but never mind, it was still occupied land.
Yes, it's still occupied land, but the point I'm making, my lord, is that Whether that's whether if the decision had been made to seek a Section 77 had appreciated when then looking at Section 77 notice and saying
Well,
actually,
771C, yeah.
771C, when we will first need to serve something withdrawing consent. I obviously
No, the answer is we don't know.
we don't know. All I'm suggesting to you is there's nothing to suggest positively that would have made a difference.
Quite.
But
I'm just being frank with you. One can't resist a feeling that we wouldn't be here if they had focused on the fact that they were doing 77(1)(c, because any lawyer would say, well, we better terminate their consent.
And I'm quite open in saying we wouldn't be here if we'd have just sent, a letter to them, or even verbally informed them that, look, I'm sorry, but we're going to have to, in a couple of weeks, serve a notice for you to.
Yes, but this ties in with the question which I wanted to ask, which is how the judge below approached this. And of course, in a sense, this is irrelevant history, given that we're now concerned with the substantive challenge.
Yes.
But if you look at his judgment, which is in the court bundle tab 7 at page 57, and it's paragraph 42 on that page. He says this: it appears to me that the November direction was on the basis that the temporary licence period was at an end. Now, first of all, do you support that way of looking at the facts? And if you do you say it's legally correct?
Well, as you know, my lord, we put it in the alternative, and aside from the argument that the notice itself is sufficient, we have put forward the argument that the licence was at an end because of the fact of the reasons for the occupation of the land was no longer operable.
And you say the two families were supposed to know that, and they were supposed to know that the council was of that view. So they were supposed to know, e.g., that the council agreed that they'd had a sufficient grieving period, without any communication to that effect.
Well, I don't think it could possibly be said that. I wouldn't quite put it that way, because I say that we didn't have to be satisfied with that fact. Because ultimately, if the local authority, having decided that the welfare issues were no longer as they were when the family came onto the land, ultimately they would have to go down the Section 77 route. I mean, there are some alternatives, but generally speaking, they would have to go down the Section 77 route. And when they did that was obviously a matter for the local authority, because of course it's for the local authority to make a decision what the position was at any particular time, for the reasons I've set out in our skeleton argument. And that therefore, certainly at that point, the family have known. That's why there's a slight overlap between my two arguments. That there was certainly at that point the family would have been had it confirmed. Although, as I say, we say that they knew the reasons why they were on the land, and that they knew the reasons more than anyone else when that period would have ended. But I, of course, accept that they didn't know on the 30th of November. That was the precise date upon which the licence was being treated as ended, or any other date one wishes to choose. They didn't have that knowledge. But I say they didn't need to have that knowledge because of the nature of their occupation. They obviously needed to treat them fairly, and what we say is that when one looks at it in the context where it's been held to be a fair treatment by the local authority of this family, it's been held that there's been compliance with intellectual quality duties, it's been held that the facilities have been found to be sufficient on this site, despite original concern. In that context, one is therefore merely saying, well, this is no longer something which is by consent, and therefore we're going down the Section 77 route. And of course, to be fair to the families, we know that they have the Section 77 protections. I don't go into the Article 8 or wider protections that my Lord referred to, but they certainly have the protections, and the simple protections, that it's a matter of time. Because, my Lord, at some point, they would have had to leave the site. If we look at it backwards, as it were, at some point they would have had to leave the site, almost inevitably, unless the council had granted them formal occupation, it was almost certainly the case that they were going to have to leave the site. This is a mere question of mechanics. I mean, we're now obviously some considerable time on from that point, and it's a matter that, of course, is still before the Magistrates' Court and still to be argued in the Magistrates' Court. But on any analysis, they are there without, on their clear knowledge, without the consent of the local authority. Whether they say that there are still welfare concerns, which gives them an argument as to what's practicable, whether or not they say any broader arguments, the difficulty for them is that they can't pursue that through judicial review because they've had that opportunity and they have not succeeded at first instance. And therefore, we say it's quite clear that a prior notice would be ideal, but wasn't required.
Could I just ask you something about the protections in section 77? Your notice, which is actually the standard notice and the only notice you're permitted to give, if you like, if you're following the unauthorised encampment policy. It's an annex to the unauthorised encampment policy. And it says you've got to leave the site forthwith, as we've seen. Now, section 77, subsection 3A says it's as soon as practicable. That's the point at which you require a criminal conviction if you're prosecuted. And subsection 5 says that you might actually fail to leave the site as soon as practicable if the reason why you couldn't go was due to illness, mechanical breakdown, or other immediate emergency, because it says it's a defence to show that your failure to leave the site as soon as practicable was due to illness, mechanical breakdown, or other immediate emergency. In other words, you're guilty, you've left, you failed to go as soon as practicable, but you have this statutory defence. You may be able to prove that there was an immediate emergency, illness, or breakdown, and so on. Doesn't that restrict pretty significantly what might be regarded as reasons for not going forthwith, and still, in other words, what is practicable here is pretty strictly defined, isn't it? Because this statutory defence is relating to matters which would otherwise be plainly relevant to what was practicable or not.
I'm sorry, my Lord, in what respect do you say that it's restricted?
Well, it's restricted because you've got a statutory defence which says, notwithstanding you have failed to go as soon as practicable, if you can show that that failure was due to illness, mechanical breakdown, or immediate emergency, then you have a statutory defence. So isn't that relevant to what practicable really means?
Oh, I see, sorry. So in other words, why isn't that within the question?
It would be, normally, if that wasn't there, you'd say, well, practicable obviously includes mechanical breakdown, wouldn't you? Because how would you get the vehicle off the site?
But equally, it would clearly, for the Magistrates' Court, they would have to decide whether, in fact, the family, certainly when faced with the Section 78 removal order application, whether, in fact, the family had or had not moved as soon as practicable. And so I understand it precisely what you're saying. There seems to be a slight disconnect between, let's say, the example of illness. I can't leave because I'm ill. I seriously can't leave. It's just simply impossible. I've got medical advice showing that. But it seems to me the notion that that would also not be dealt with by the question of practicable would be perverse because of that.
Well, it's practical.
In which case the subsection is redundant.
Yeah.
Well,
It might mean that as soon as practicable effectively means forthwith,
Which is what it says in
which
the
is
notice.
what it says in the notice. Because it, like everything else, is context specific. It could, but for 77.5, it would mean really as soon as it takes you to go back to the site, pack up your stuff, switch on the engine and go.
Well, my Lord, even if that was the case in this instance, I appreciate there may be other examples, but in this instance, even if that was the case and the practicable really wasn't as subjective as I made it out to be earlier, one still has the 5 defence. One still has the question of the fact that, I can't leave forthwith or even within a few days because of the illness. And of course, what we're talking about here are the welfare concerns in relation to the parties, in relation to the occupiers. and therefore.
Well, I'm
are
not
still
sure
their
that
protection.
I'm not sure the sorts of welfare concerns we got here would necessarily fit. Illness, not quite sure what illness means. Immediate emergency is very narrow. Anyway.
Well, but my lord, in terms of this case, one has to see it in the context where those wider arguments, which may be perfectly legitimate in general, have actually been dealt with already by the court below. You know, we really mustn't lose sight of the fact that this was actually, the grounds of challenge originally were not what we saw on the grounds of appeal, certainly were not in relation to ground one. That was really Deputy High Court Judge Edis' construction of dealing with the question of, and he himself raised the question of the notice, and did you need to give prior notice? That came out of his judgment. What we do know, as I say, that all the challenges that were made to that judicial review in the court below were unsuccessful, and that still holds good. And what that does mean is that the local authority have complied with the public sector quality duty, has complied with its welfare requirements in relation to the guidance and so on. And of course, the one issue remaining, which is the issue that was raised in the judgment of the Deputy High Court Judge, was the question of notice. Because he raised it, and although he dealt with it in a fairly quick fashion, because it was just simply a bit of, you know, what do you say about this part of his part of the submissions? This has to be seen in that context. So, having done all that work with this particular claimant, one then sees, okay, so what is the question? Either you have an illness, or you would argue for some reason you can't move. And we don't know. We don't know, but we do know that those challenges that perhaps can't be dealt with by the Magistrates Court because of the Wolverhampton case have been dealt with by the Administrative Court last year, and have been dealt with in favour of the local authority. So I do take my lordship's point, and I do see the argument very much that perhaps it's a much harsher interpretation of the suit practical as I've been given, but it is certainly not a definite term. It certainly doesn't say forthwith, for example. And I suggest, my lord, that it must be referable to the defendant in issue and their circumstances in some sense. Perhaps I can just turn my back. My lord, perhaps I can just check my speaking note, because as always on these things, there's things that have been taken out of.
No, it does happen. No, of course, just do it by all means.
One thing I did want to stress, and as I say, it may be something that you feel is not particularly relevant at this stage, but I do want to stress what was known to the particular claimant. When I say the claimant, I mean people on the site, her family. I don't mean SO herself. We haven't seen anything from SO. We've already had reference to the Code of Conduct. We've had reference, I believe, to the equality impact analysis.
What? Sorry, what? Are you suggesting that was known to the family on the site?
Well, the reason I say that is if one looks at page 258 of the supplementary bundle. You'll see it, question 3, the assessment concerned the provision of a short-term negotiated stopping site and identified that the council will provide, I'm sorry,
258.
258. question 3, section 3, dealing with the provision of short-term negotiated stocking site, and identified the council will provide a temporary site for a period of approximately 5 months to meet the welfare needs of 2 individuals.
Yes, but well, we know about that. But as I understood it, there was never any suggestion that the families themselves knew about that 5-month figure.
Well,
And indeed, I think certainly Ms. Constantine, if I remember the name right, who's the nearest, says, who was effectively acting for them, says she didn't know anything about it.
well, we don't know what SO knew about it.
But why would she know about the contents of an equality impact assessment?
Well,
It's not something that's for public consumption.
I'd agree, Norman. I don't want to overblow the equality impact assessment. This was, as my learned friend said, provided to the families when they got the section 77 erection notice.
Yes, but I dare say, but the point is, if they weren't shown it before, it goes nowhere.
We also have statements in this bundle, such as at 323.
Which page? Sorry,
323.
323.
Is from one of the individuals we're concerned with, Mary McGinley. Talks about the previous experience for Section 77 notice, which we know about in May 2021, which was led to the.
Incidentally, sorry, anonymous. We have. I haven't troubled myself with the exact terms of the anonymisation order. We're calling SO.
Yes.
You've just named another name, but that's not covered by the anonymisation. No,
I don't think so.
That's fine.
But thank you for. I'll be careful. And then it talks about after the magistrates refused the removal application. Let's say that's the May 2021 provision on the previous site. The enforcement team came to the Princess Walk camp, spoke to myself and my sister-in-law Nora about a plot of land they were going to offer us at the order of the magistrates. They made no mention of the facilities for this, other than it was a place we could stay while our health wishes were looked at.
But sorry, this is just making good what is clear enough from the code of conduct that they knew that this was in a broad sense temporary because of the welfare issues. That's not in dispute.
I won't labour the point, my lord.
The question really is whether they were entitled to some form of notice before that temporary provision came to an end, before the criminal draconian sanctions were applied to them.
Yes, I accept that, and I say that there was certainly no proprietary interest or right which was entitled to that in terms of.
No, it's not about proprietary interests. It's about your client's duty to act fairly.
Absolutely, and I was going to say in terms of obviously, particularly with a criminal sanction available, and I say it wasn't because of the fact that although we could produce such a notice as we did, clearly we couldn't require them to move. Unless they do so as soon as practicable. B, if they try to claim any and C, in any event, of course, without the removal order of the magistrates.
Yeah,
the magistrates being satisfied with those facts and the normal process of the magistrates' court process. This isn't a situation, for example, like a housing case. One is looking at a notice seeking possession, which gives 28 days for certain grounds of.
Yeah, you made that point earlier, and I'm still a little puzzled as to how it applies in this context. So, can we just take section 77?
Yes.
And we're all agreed that, in fact, the relevant provision is 77(1)(c). So, if it appears to a local authority that persons after the time being residing in vehicle buildings within that local authority's area on any unoccupied land without the consent of the occupier, the authority may give a direction. So it's a condition precedent to the authority giving the direction that the persons in question are on the occupied land without the consent of the occupier. Now in our case, SO's case is very simple, namely that as of the date, she was there with the consent of the occupier, look at the terms of the code of conduct, which is the best evidence. Your primary case is that the giving the direction overrides that. And how, as a matter of statutory construction, do you arrive at that result?
Yes, well, actually dealing with that first, because I was going to deal with that other case. But in terms of that one, it's, of course, first of all, it's a question of what appears to the local authority. So that's the first reference that's needed to be considered. And of course, it's therefore dealing with people for the time being. In other words, that situation may change, but of course, it's for the time being. And clearly, if the local authority have, as we say, and we say there is evidence of the fact, made a decision, which of course must have made a decision, not only because of the references you've been taken to in Miss Turner's statement and the exhibit to Miss Turner's statement accompanying the direction notice of November 2021. If they've made a decision that consent has been withdrawn, effectively, there is no consent any longer of the occupier. In other words, the local authority no longer, at that point, I appreciate there's a point of yes, but you haven't.
But are you saying that consent that consent is in all circumstances unilateral, that you can withdraw your consent silently?
I say that we're entitled to withdraw the consent, but of course, in terms of them being able to do anything with it, the notice is either notice.
The consent is of its nature bilateral, isn't it? It's saying to someone that you agree to them doing something.
It's the local authority saying that we agree to you staying here temporarily. And if the local authority has made a decision, even a unilateral decision without at that time service, obviously at some stage there'll be service, but at that time without service, it is entitled to say our consent has been withdrawn. We don't need, for example, we don't need to negotiate. We don't need to have any prior negotiation with you.
No, well, that's fine, but you still do have to communicate the withdrawal of the consent, I would have thought, except in the case which we discussed earlier, but isn't this case, where the consent is self-limiting, where the consent says it ends after X days or after the fulfilment of some condition that everyone knows has been.
Well, my lord, the way I would interpret this and put the submission to your lordships is simply that that's not right, and that all that's required is that, does the claimant have the consent of the occupier? I say, as a matter of fact, no.
Yeah. Okay.
She doesn't. Now, of course, what we do with that, clearly we can't then do, because they are draconian powers, we can't simply then go to remove the caravans. We've clearly got to go to court, got to issue a notice at that point. That will be served if that's how it's done. It has to be said, my lord, this is not a usual situation. Most of these situations, the vast majority, of course, are going to be situations where people have occupied land right from the start without consent. There's never been any.
All right, but that's slightly double-edged from your point of view to make that observation.
Well, I think it's legitimate. I mean, I don't make it for any kind of. I make it by way of background rather than by way of submission. But in those cases, of course, it's all the more obvious. But of course, for example, if one had allowed, let's say, had allowed them to stay for a number of months, not done anything about it, not issued any notices or done anything about it, and then 10 months, 11 months after occupation, simply issued without any notice, Section 77, would that be sufficient? And we said, well, yes, because you've never had consent to be on our land, even though you've actually been on our land for 10, 11 months. And we say that wouldn't be with consent. And equally, in a different scenario, of course, we would say that once we're entitled to give consent, we're entitled to withdraw consent. And once we've withdrawn consent, Section 77...
Well, I think we're really going over the same points again.
No, but Section 77 then operates, and then, of course, notice is then given. Yeah. But as I say, the alternative argument as set out in the scope of argument is that it didn't even need to reach that point for the reasons that we say, because the consent had been withdrawn in any event by reason of the...
not had been with... Oh, I see. I was just going to ask you, you referred us, by way of intervention, Mr. Baldwin's submissions, the case of CN and Lewisham, which we haven't got, we may or may not think it's necessary just to have a look at it. But is there anything about that case? You said it was in your speaking note. What were you going to say about it?
Oh, I think, let me just check where it is in my speaking note. I just did a compare with. Yes. About the need for any pre...
Well, I'm not particularly wanting to raise a whole thing about it.
No,
we haven't got it in front of us, but I just wanted to make sure that anything you had wanted to say about it, you've said. In a sense, I think my Lord's question about the Housing Act analogy was probably raising that point without referring to it.
As I say, if you wish us to provide you with the authority, I can obviously make sure that we do so.
We can find it easily enough.
Well, perhaps I can just turn back to see if there's any further submissions. I have no further submissions, my Lord, unless you have any questions.
I don't. Neither do my Lords. Yes, thank you very much, Mr. Lane. Any reply, Mr. Baldwin?
No reply, my Lord, unless your Lordships have any particular questions for me.
Yeah, I wish we heard that more often. That's a perfectly sensible position we've been able to provide very clearly. Well, we will be reserving our decision. The normal procedure will be followed. That is to say, copies of our judgments will be circulated in draft to those people whose names were supplied on the form shortly before this hearing. It's circulated only for the purposes which I needn't remind you of. You can look at the Counsel General for Wales case if you want to be reminded. So any further circulation within teams and so forth, or within particular parts of the client, should only be for those purposes and no other. Our particular concern is obviously to have the parties agree the terms of an order, or if they can't agree the terms of an order, to provide short written submissions so that we can resolve that and produce an order at the time of the hand down. Also, of course, interested in typographical or other minor factual errors. Thank you all very much.
All right.